instance, and in the second instance, I mean, there's no benefit at all of recalling this bill. I got an idea that if the senator from Beaufort, who's not on the subcommittee, will come to our meeting and we can have a more constitutional discussion as the senator from Charleston and I were just having, I have great confidence in his understanding of the Constitution and the separation of powers question, and I believe that we can be successful in our arguments with him.
But Senator, I understand, and you're telling us that you're against this motion and you'd prefer it to go through the subcommittee process, which I appreciate your comment on that. My question is, should the motion pass, are you then going to ask us, say, well, you know, we did put it on the calendar, let's bring it through the subcommittee with it maintaining? Is that what you would suggest?
Well, if the Senate, it would take a unanimous consent request to do that.
That does take unanimous consent.
That would take unanimous consent at that point, and I think the chairman of the committee would object to that. Yes, sir.
Senator, to yield.
Senator from Lexington.
Senator from Pickens, I was hoping the senator from Beaufort would hear my question, but did I understand you to say you already, before today, had a subcommittee hearing?
Last year, when Senate Bill 11 was
No, but I'm
introduced.
talking about on this year.
Not on the House bill. No, not on Senate Bill 11. We didn't meet again this year.
Talking about the bill that he's moved to recall.
We have not met on it. We just came over a couple weeks ago.
I'm getting to that next. But my question is,
I got a written request from a member to take it up, and I've honored that request by asking staff to set it for a meeting, and it will come up the first week in May when we come back after the budget.
you apparently misunderstood my question. My question was, you have scheduled a subcommittee hearing.
I have.
And this bill only came March 30th.
That's correct.
So it's been here about two and a half weeks.
Right. 3 weeks, because we were out the first full week.
I would hope the senator from Beaufort would at least talk about the committee system and the subcommittee system before you insist.
Right. I would move table the amendment. Motion, I'm sorry. He would like, I withhold that motion.
Beaufort's recognized.
Mr. President, I'll be brief. I realize only limited comments are allowed on a motion, but I've tried cases and argued cases across the street before the Supreme Court. I know this Constitution inside out. I am aware of the provisions they're citing in Article 3, Section 12, that each House shall determine its own rules of procedure. If this body decides it wants to dictate those rules by statute, there's nothing inconsistent with the Constitution here. There's absolutely nothing inconsistent. And what I find ironic is that somehow the state constitution is being used as a shield against more on-the-record votes. And I just don't believe, you can't convince me that the state constitution is going to be interpreted by that Supreme Court in such a way as to limit the people's right to know how their representatives are voting on an issue. I don't believe it. I don't make these motions lightly. It's the first time I've ever made a motion like this. I don't think this matter is going to be able to make its way through the committee system, given the calendar we have. I think this is the only practical way we're going to get to it this session. Otherwise, I'd go through the committee process. Senator Peeler has had his bill filed for months and hasn't gotten a hearing. And I honestly believe this is the best way for us to consider this. I promised my constituents we'd do that. And I don't think the state constitution is ever going to be interpreted in such a way by that Supreme Court as to limit the people's right to know how we vote on issues. I don't believe it.
Well, Senator Yield.
Senator Yields.
Senator, would you accede to one correction of your comments? Number one, the committee did have a hearing on Senator from Cherokee's bill.
Okay, I was mistaken. It wasn't passed out. I apologize.
It was not passed out because of the information that and as I said earlier, would you not welcome the opportunity to come to the meeting? I don't think you were at that hearing when we had it, and we can discuss. I think there's a legitimate difference of opinion on our parts about, and I didn't say it was unconstitutional. The court, I would never make the argument of the representation of the Senate or to anybody else that this would be struck down as unconstitutional. I was talking about the judicial review that would be given to it. The judicial review that would be given to it, would you not agree, based on your reading of past cases, all those bobtailing rulings, they go back and they talk about what's in the state constitution.
They do,
And
but
they specifically say in their I can and we'll get those. They specifically say in their site they don't look to the statute, they look to the Constitution.
But the Constitution enumerates certain things that must be subject to a vote, but that in no way precludes this body from expanding that recorded requirement. There's nothing precluding us from doing that.
We've done by rule, but also, which I am not willing to delegate to the other house or to the executive, as you apparently are willing to do, by passing a statute.
And that's a debate on the merits, and we can have a debate on the merits, and there may be arguments against and for this bill. I'm just simply wanting it on the calendar.
And then I'll leave you with this. The next question is what else is going to be the fad of the moment that we're going to delegate to the governor, to the other house, to put some sort of, quote, control or restraint or transfer, whatever it is.
Senator from Pickens, I respectfully disagree that recorded votes are a fad of the moment. I think this is critical to representative democracy.
Let me tell you something. The Rule 16, the last thing, have you seen the emails going around that Senator from Charleston, Senator from Pickens, they don't want Senate to be on the record at all. They want secret votes, as though Rule 16 doesn't even exist.
Senator Pickens, one of the things I committed to my constituents was that I would do everything that I could to make sure this particular bill got brought up this session so that more votes were on record. And I feel like I'm doing my job.
Well, you are, and I have great respect for you. We have a genuine difference of opinion, but nevertheless, I have a great deal of respect.
Thank you.
Sir, the bulldog back there was actually next.
I yield to the senator.
Senator from Charleston.
Thank you, Mr. President. Ladies and gentlemen, Senator, I'll be very brief. This has absolutely nothing to do with whether or not we're going to have more roll call voting. Roll call voting is provided by Rule 16 pursuant to the Constitution of the state of South Carolina. If you want more roll call voting than what we got, put a Senate resolution in to amend the rules. The senator from Pickens and I put a resolution in over a week ago that requires recorded votes on everything. And so if you want that, Senator from Beaufort, you should join us as a co-sponsor. But ladies and gentlemen of the Senate, this is a question to me of the constitutional separation of powers, the express language of the Constitution. I consider it a violation of my oath of office to uphold the Constitution, to vote for a ragged piece of legislation like the House of Representatives sent to this Senate, which was a political trick over there, in my opinion, dealing with gubernatorial politics rather than the merits. This whole thing is turned into a political charade across the state. You want more roll call voting? You should have offered amendments at Rule 16, right here on this floor when that rule got adopted. You ought to put in Senate resolutions to what you want to go to. The Constitution gives every single member of the Senate that right. What it doesn't give to this body is the right to subject these rules to a vote of the House of Representatives or the veto of His Excellency. A statute cannot trump a rule. It goes way back in American constitutional law, and I believe, Senator from Charleston, to the political question being raised in Marbury versus Madison, all the way back in U.S. constitutional history. I don't know how to explain it any clearer to you than that a political question is an internal question to a separation of powers in a body. Go read the recent court case on the Judicial Screening Committee. They had to address it right there as to whether or not this body could, with the General Assembly, screen those candidates, disqualify. It is so elementary, but it is difficult to explain to people who have not had courses in constitutional history. But in a nutshell, I want to make it perfectly clear. The Committee system is there, and